attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a Lawcast series detailing the OTCQB listing requirements. Effective July 10, 2015, the OTC Markets amended its rules related to the OTCQB listing standards to include initial and ongoing listing requirements for companies completing a Regulation A+ offering. This Lawcast series will include a comprehensive overview of the OTCQB requirements as of August 2016. To be eligible to be quoted on the OTCQB, all companies are required to meet a minimum closing bid price on OTC Markets of 1 penny for each of the last 30 consecutive calendar days immediately preceding its application. In the event that there is no prior public market and a 15C211 application has been submitted to FINRA by a market maker, OTC Markets can waive the bid requirement in its sole and absolute discretion. In the event that a company is a seasoned public issuer that completed a reverse stock split within 6 months prior to applying to the OTCQB, the company must have a post-reverse split minimum bid price of 1 penny as of the close of business on each of the 5 consecutive trading days immediately preceding its application to the OTCQB. In the event the company is moving to the OTCQB from the OTCQX, it must have a minimum closing bid price of 1 penny for at least one of the 30 calendar days immediately preceding its application. Companies applying to the OTCQB may not be subject to bankruptcy or reorganization proceedings. Companies must either be subject to the reporting requirements of the Securities Exchange Act of 1934 and be current in such reporting obligations, or be a Tier 2 Regulation A+ reporting company and be current in such reporting obligations, or if an international issuer, be eligible to rely on the registration exemption found in Exchange Act Rule 12G 3-2B and be current and compliant in such requirements, or be a bank or bank holding company current in its reporting obligations to its bank regulator. A company must be duly organized, validly existing, and in good standing under the laws of each jurisdiction in which it is organized and conducts business. A company must submit an application and pay an application and annual fee. It must maintain a current and accurate company profile on the OTC Markets website. It must use an SEC registered transfer agent and authorize the transfer agent to provide information to OTC Markets about the company's securities, including but not limited to the number of shares authorized and the shares issued and outstanding and a share issuance history. And a company must submit an OTCQB annual certification confirming the accuracy of the current company profile and providing certain information on officers, directors, and controlling shareholders. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.